Well, after sorting out a few technical hitches, I think we're now ready to resume. Mr. White.
Thank you, my lord. My lord, before the short adjournment, I was showing the court some of the early authorities on the representative action rule and the way they had treated an attempt to pursue a representative action for damages on behalf of each member of the represented class. The same approach that we saw taken in Marked was taken by the Court of Appeal in the next case I come to, David Jones against Corey Brothers and Co. Limited in 1921. My lord, it's reported fairly briefly in both the Law Journal and Law Times reports, but it's a strong Court of Appeal and the outcome is clear, although the extent to which the judgments are reported is limited. It was Lord Justices Banks, Atkin and Scrutton. It was, sorry, I should have said, it's page 903 is the Law Journal report, and then we have transcribed at 907 and 909 the reports because they're slightly difficult to read in the photocopies of the pages. There were two claims brought as representative actions for breaches of statutory duty by employers. In the first case, the breach of statutory duty was an insufficient number of safety lamps. In the second case, it was the position of a weighing machine. And the representative claimants in each of the three cases sought, firstly, declarations, secondly, claims for damages on their own behalf, and thirdly, claims for damages on behalf of each individual represented member of the class. The defendants objected to the representative nature of the claim, and that objection was tried as a point of law. In the Court of Appeal, the court held unanimously that the third claim, namely claims for damages on behalf of each individual represented member of the class, could not be pursued as a representative claim. The court divided on whether the declaration claim could be pursued in a representative action, but what's important for present purposes is the disposal of the claim for damages on behalf of the class members. It's not clear from the short reports whether Marked was cited, although it's almost inevitable. I would respectfully submit that it would have been. But in any event, the holding in relation to damages claims on behalf of class members is clear. And in some ways, it may be the closest case to the present because it's an attempt to bring a representative action for individual claims for damages for breach of statutory duty. And it wasn't allowed. And the respondent can point to no later case where such a claim has been allowed to proceed as a representative action. My lord, the next case that I wanted to refer to was Prudential Assurance. That's at page 911. It's important largely because Mr. Justice Vinelot conducted a very careful review of the Marked and David Jones and Corey Brothers decisions, including obtaining with the assistance of counsel the order of the Court of Appeal in the David Jones case from the Public Records Office, we see from his judgment. And he concluded that those authorities established that you couldn't claim damages on behalf of the represented class members in a representative action. There's some discussion about the availability of a claim for a declaration, but he held in essence that you couldn't do that either if it would close out any defence the defendant might have to individual claims and damages. And I just wanted to emphasise, because that's a formula that one sees from time to time in the cases, I wanted to emphasise that it's important to remember a defence to an individual claim may include a claim as to quantum or causation, as well as a defence as to liability. And the holding was that you couldn't, by means of a declaration, shut out the defendant from taking points in defence of individual claims that would be available to them in an ordinary action. My Lord, the next case it's worth noting is the Smith and Cardiff Corporation case. That is at page 1586. I just need to change bundle. Smith and Cardiff Corporation is another Court of Appeal case, but its interest lies in the fact that even a claim for a declaration was held to be relief which was not beneficial to all, where the members of the class were affected differentially by the alleged unlawful conduct. So it's a case in which the local housing authority had passed a rent increase, the impact of which varied between members of the represented class. In essence, tenants with higher household incomes under the rent variation passed by the council would subsidise those tenants with lower household incomes. And so even though the case was brought for a declaration and an injunction, a declaration that the increase was ultra vires and an injunction to restrain its implementation, the Court of Appeal held it couldn't be brought under the representative action rule because that relief was not beneficial to all. And we see at 221 in the judgment of Lord Evershed, Master of the Rolls, 221 is page 1597, that the first instance judge, you see this in the bottom quarter of the page, the first instance judge, Mr. Justice Glyn Jones, was said by the Master of the Rolls to have rightly concluded that the third qualification in Lord Macnaghten's dictum is not here fulfilled. That's the relief must be beneficial to all. And he makes the point at the top of 222 and down to the bottom of the first paragraph on 222 that the effect of the rent increase will impact differentially between different members of the class, and that there will be not only those with intermediate positions, but also those at the bottom and those at the top end who would be differently affected. And his ratio appears halfway down 1598. He said, I need not, I think, pursue the matter beyond pointing out that there are, apart altogether from those in an intermediate position, two distinct classes whose interests are in conflict. Those who will benefit by having no increase or no present increase on the one hand, those who will have what may be called inflated increases on the other. I therefore prefer to base my conclusion that this case doesn't fall within the strict terms of the rule upon that point, rather than deciding whether it falls in limine, because there is here no class of persons having the same interest in any cause or matter. I showed you in particular the way it's expressed at 221 to show that that reasoning is tied to the third requirement of Lord Macnaghten. My Lord, although representative actions seeking damages have since been allowed in certain specific situations, none of them come close to the present case. One type of case where representative claims for damages have been allowed is in copyright piracy, where members of collecting societies have assigned their pecuniary claims to the society. In claims brought in that situation for both injunctive relief and damages claims, the courts have allowed the representative action procedure to be used. But the key to it is the assignment of rights, so that there is one pot beneficial to copyright owners in general, which will be applied to further their interests. And the judge deals with that exception at paragraph 87. We say in our case that Laddie, Prescott and Vittoria capture the essence of that type of exceptional case, and we've given the quote. The page reference for that is 3692, but I won't pause on it. We're a long way from that situation. Then there are cases where claims against representative defendants, which is altogether a situation, have been allowed to proceed. And the respondent relies heavily on a case called Irish Shipping against Commercial Union, which is at page 972. But the important features of that case, which mean that it's of no assistance in the present, is that the claims were not brought for seeking damages on behalf of the members of a represented claimant class, but were brought by a claimant against a representative defendant for liquidated damages, liquidated sums due under certain arbitration awards. And so the first point is it tells you nothing about claims on behalf of represented claimants for damages, but in any event, it involved represented insurer defendants who had all signed a leading underwriter clause under which they were bound by any finding that the court should make, and their proportionate shares of the liquidated sums claimed were clear from the contractual arrangements. And so although Mr. Pollock made the ambitious submission that Marked ruled out any claim in a representative basis, either by claimants or against defendants where damages were the relief sought, that submission fell on stony ground, but in a factual situation very different from the one with which we're concerned. Lord Justice Staunton observed at pages 226 to 7 that the rule was more flexible than Marked left it, but it's interesting to note that Sir John McGaw and Lord Justice Purchase both found it necessary to distinguish Marked, even though it was a claim against represented defendants, and did so on the basis of the leading underwriter clause. But we say that case, which is perhaps the high watermark of the authorities relied on by my learned friends in this jurisdiction, doesn't assist and doesn't undermine at all the consistent line of authority to which I've drawn attention. My Lord, the Chancellor at paragraph 73 brushed aside, if I can use that expression, the weight of authority which I have shown you as historical twists and turns, which he said he got no assistance from. In our submission, that's not an entirely fair characterization of the pattern of authority. We would say rather that there is a fairly straight path starting from the Duke of Bedford and Ellis dealing with a case such as the present, and that the judge rightly held at paragraph 88 that subsequent authorities have adhered to the main principle. The only case the Court of Appeal dealt with in detail was, which they described as the latest authoritative and relevant interpretation of the rule, was a case called Emerald Supplies and British Airways, which does bear some resemblance to the present. Properly understood in our submission, the decision of the Chancellor, Sir Andrew Morritt, in Emerald Supplies, which was upheld by the Court of Appeal, and the Court of Appeal's own decision in that case, are consistent with Marked and support our argument. My Lord, the Chancellor, Sir Andrew Morritt's decision is at page 1031. The reason there are some echoes of the present case, or some echoes of Emerald in the present case, are that there had been previous regulatory action and criminal proceedings taken against British Airways in America, Australia, and New Zealand for participating in a worldwide price-fixing cartel. And there was also an ongoing EU Commission investigation about the cartel. The claim was brought against British Airways after it had been convicted of that anti-competitive behaviour overseas on behalf of certain importers of cut flowers who had used British Airways air freight services. And they brought the claim on behalf of all other purchasers of air freight services who'd suffered loss as a result of BA's anti-competitive practices. The relief sought, and this echoes a point I made to my lady before lunch, was a declaration that damages were recoverable in principle on behalf of each member of the class. British Airways applied to strike out the representative claim on the grounds that the claimants didn't satisfy the same interest requirement. And that application was granted on two bases. The first basis at paragraphs 34 to 35, which I'll come back to when I deal with identifiability, was that the formulation of the class, comprising all those who'd suffered loss, meant that inclusion in the class depended upon the action succeeding and a finding being made that they had suffered loss. And it was held to be illogical that your class depended on the outcome, and the statement was made that you had to be able to tell at any point in time whether somebody was or was not in the class. But the second reason given by the Chancellor at paragraph 36 has more significance perhaps for the present case. His separate and additional reason was that because damage was a necessary element of the cause of action of each individual member of the class, that meant that their interests were inevitably, as he put it at 36, in conflict. He doesn't mean conflict in the sense of principled opposition. That becomes clear from a later paragraph of his judgment, paragraph 37. Do you see at letter B on 37, he says the conflict between different members of the class is not a consequence of any esoteric defence of passing off, but is inherent in damage being a necessary ingredient in the cause of action. So he uses conflict in the sense of not having the same interest because you have individual claims for damage. And that second reason, as was the case with the first, is upheld by the Court of Appeal. But before I leave the Chancellor's judgment, could I respectfully commend what he says in paragraph 37 just above letter B, where he says, the problems the claimant's advisors anticipate are better dealt with by Parliament than by stretching the use of Rule 19.6 to accommodate cases such as this. And we fasten on to that and respectfully submit that that is a telling and correct observation. Lord Emerald supplies in the Court of Appeal is at page 1046. Lord Justice Mummery, with whom Lord Justices Toulson and Reimer agreed, upheld the whole of the Chancellor's judgment, saying at paragraph 68, there is nothing wrong with Sir Andrew Morritt's judgment. The case is interesting because Lord Justice Mummery began his judgment by saying the appeal was a bold attempt at keeping a procedural novelty alive. And one sees in paragraph 2 that the Court of Appeal were pressed with the sort of policy arguments in favour of collective redress, which are placed before the House by the respondent, before the Court by the respondent in the present appeal. Lord Justice Mummery essentially upheld the two reasons for striking out the representative claim given by the Chancellor at paragraph 62 to 3 and 64. In 64, dealing with the second difficulty, so the second difficulty, sorry, this is 1062. A second difficulty is that the members of the represented class do not have the same interest in recovering damages for breach of competition law if a defence is available in answer to the claims of some of them, but not to the claims of others. Now, my Lord, importantly, given the conviction of British Airways overseas, what he is talking about in that paragraph is claims as to quantum or causation more than, defences as to quantum or causation more than defences as to liability. And in our submission, when the judge referred, as he did in our case, to Google having a defence to some of the claims in relation to the categories of information obtained, he had effectively something similar in mind. Not necessarily a defence as to liability, but a defence as to quantum or causation. My Lord, in discussing the authorities and on rereading this in preparation for the appeal, I spotted that Lord Justice Mummery refers with approval at paragraphs 50 to 51 to a Manx case that Lord Justice Toulson had obviously referred to in argument. That case is called Radcliffe against Coltsfoot Investments Limited in the Manx Law Reports for 1984 to 1986, in which it turns out Lord Justice Toulson, as junior counsel, had appeared, and he had recalled that case, which was drawn to the attention of counsel in argument. We've dug it up and put it in the supplemental authorities at page 473, and it is consistent with Mark and indeed with my thesis. It was a claim for damages for breach of statutory duty by a number of bank depositors. Each had a separate claim for breach of statutory duty, and the relief claimed was damages or a declaration they were entitled to damages. And the I think it's the Staff of Government Division, which is what the Court of Appeal is called in the Isle of Man, rejected that claim as a representative action on the basis of the English authorities starting with Duke of Bedford and running through to Prudential. In particular, at page 142 of Radcliffe and Coltsfoot Investments, we see the finding that it's page 488, that the English authorities show that representative proceedings can't be used where the relief sought is damages. So, my Lord, it's just interesting to see that Lord Justice Toulson had recalled that, and it is consistent with our analysis of the authorities. My Lord, between the decision of the Court of Appeal in Emerald Supplies and the decision at first instance in the present case, Mr. Justice Edwards Stewart decided a case called Rendlesham Estates and Bar. That is page 2452. That was a case under the Defective Premises Act, where a necessary ingredient of the cause of action was proof of damage. And Mr. Justice Edward Stewart, applying the authorities on which I've founded, held that where proof of damage is an essential ingredient of the cause of action, no two represented claimants have the same interest. And he says in terms, if damage is the ingredient of the cause of action, a representative claim could not be maintained. The relevant paragraphs are 88 to 90 and 270. My Lord, I've counted through the case law because time is limited, but I hope I've done enough to show that there is not a precipitous twists and turns, but a fairly clear and straight path from Duke of Bedford through to Rendlesham Estates and Bar, and that in those circumstances we submit the judge was right and indeed bound to follow that consistent line of authority and hold the action cannot proceed as a representative claim seeking damages in the way it's formulated. The two reasons for that in the strands of the authorities are, firstly, the members of the class don't have the same interest because none have an interest in each other's damages claim. The second is that the defendant may have separate defences, in particular as to quantum or causation to the individual claims. So how then does the Court of Appeal, I'm sorry, I see my Lord Legate's hand up.
Yeah, I'm just interested in the policy underlying that position, what you say it is, Mr. White, because I don't find terribly illuminating just discussing what same interest means, because it could mean all sorts of different things. But I mean, is the policy really that if the claim involves, if you have to look at each person's individual circumstances in order to find out what loss they've suffered or whether there is a claim against them, it's not appropriate to do that without their participation in the proceedings?
Well, Lord, you can answer that in two ways. One looked at the history of the rule. That was for relief which was common to the members of the represented class, and it was a procedural and convenient rule where a claim to establish a right or to prevent a wrong which affected people in common was brought. That didn't include damages, but history doesn't, I accept, determine availability fully, and the modern cases have perhaps concentrated more on the difficulty of allowing something to proceed as a representative claim without the individual circumstances of the represented class members being before the court, when those circumstances might allow the defendant a different position vis-à-vis each class member. How then does the Court of Appeal address that requirement? The Court of Appeals say at 75 that each member of the class did have the same interest once the representative claimant disavowed any reliance on any facts affecting any individual represented claimant. This has, the Court of Appeals has the effect of reducing the damages that can be claimed to what may be described as the lowest common denominator, but it leaves them in a situation where the wrong is the same and the loss claimed is the same, and so they do then, in the relevant sense, have the same interest. And that, as we know, was explained by the Court of Appeal at 77 as allowing a lowest common denominator uniform sum to be sought. And as I showed you this morning, the way in which that was to be assessed or calculated appears in the last few lines of 77. My Lord, we say there are at least 6 objections to this attempt to meet the same interest requirement by disavowing any reliance on individual circumstances. The first is that the tactical disavowal of reliance on individual circumstances doesn't alter what those individual circumstances in fact are. The class remains a disparate group, ranging from those for whom the breach of duty had no significant consequences to those for whom it may have had significant harmful consequences. And just disavowing the difference between them doesn't alter the actuality. That's the actuality in fact. The second objection is that the disavowal of reliance on individual circumstances doesn't alter the legal nature of the claim advanced by each member of the class. They remain separate claims for breach of statutory duty to recover damages for the harm caused to the individual in question by the breach. The third objection we respectfully submit is it's one thing to limit one's own claim for damages. The respondent says, well, sometimes one might say, I'm going to limit my claim to the county court limit to avail myself of the county court forum. But it's altogether another thing, is it not, to limit the claims brought on behalf of millions of other people without their knowledge or consent. That, in our respectful submission, is unprecedented and unprincipled. My fourth objection is that the lowest common denominator exemplar is a fiction. It's not a member of the class at all, but a notional or fictional member of the class. And my Lord, I've touched on why the lowest common denominator needs to be viewed from the perspective of the extent and nature of the information in question. And we've discussed that, I think, sufficiently. But there's another point that occurs to Mr. Craven and I as we prepare for argument today, which is when, within the relevant period, is the lowest common denominator exemplar affected? Because just as someone could obtain their iPhone on the last day, someone could lose their iPhone or have it stolen on the morning of the first day And if you don't know when within the relevant period the exemplar is impacted, how do you address questions such as limitation or the entitlement to interest? Or, and you'll recall me asking you to read paragraph 41D of the particulars of claim, the defendant's changing state of knowledge. On the claimant's alternative case, someone who lost their iPhone on the morning of the first day of the relevant period may have done so when the defendant's breach was not deliberate. Lord, all of these problems illustrate the unreality of the lowest common denominator approach. My fifth objection is one that I'm obliged to two academic commentators on this case for, and it's this. Both Mr. Goutsamanis and Professor Mulheron have pointed out that the disavowal of individual circumstances can work in justice to claimants who have larger claims than the claim of the lowest common denominator exemplar. The Court of Appeal in our case, at paragraph 76, thought this didn't matter because the limitation period had expired. But that was just happenstance. This will have to work in a situation where the limitation period hasn't expired. And what Mr. Goutsamanis and Professor Mulheron point out is that where the limitation period hadn't expired and someone had a claim for greater than lowest common denominator damages, their involuntarily self-appointed, I'm sorry, I'll start that again. The involuntarily represented claimant with a larger claim who's unaware of the proceedings or the disavowal of their personal circumstances by the representative risk the prospect of recovering their greater losses disappearing as a result of either CPR 19.64A or res judicata or abuse of process. Mr. Goutsamanis points that out at page 3731 in his case note on the Court of Appeal's decision, and Professor Mulheron in her latest article on the case points out the same problem at page 774 of the supplemental documents. Lord, in our submission, that is a sound objection, and it echoes the judge's point about why the lowest common denominator damages were unprincipled. My Lord, the sixth objection is that it's contrary to such authority as there is to artificially fix or limit damages claims rather than allowing the court to assess the damages to which an individual claimant is entitled. There isn't much authority, but such as there is hostile to that approach. We cite three cases. The first is the well-known case of Adams and Cape Industries. That is at page 1674, but I don't think we need to turn it up. Let me just explain the way the problem arose in that case. In that case, there had been group litigation in Texas against Cape Industries arising out of the use of asbestos in buildings in the United States. Judgments were obtained for one or other of, I think, three tiers or bands of uniform compensation, and the claimant's solicitors, rather than the judge, had allocated claimants within the group litigation to the bands. Mr. Justice Scott, at first instance, refused to enforce the Texan judgment in this country on the basis that the allocation by the claimant's lawyers of individual claimants to these bands was arbitrary and therefore offended against English law principles of substantive justice. That's at page 500 of the judgment. I'll just find perhaps the electronic page number. And yes, it's 1741, and the Court of Appeal upheld that at page 566 to 568, which is electronic page 1809. But it's a strong thing in our submission for the court to have said that the allocation, not by the judge, but by the claimant's lawyers to a uniform category of that sort, offended against English law principles of substantial justice. Lord, the second case we cite is the decision of the Supreme Court of Canada in General Motors against Nakin. That is in the supplemental authorities at page 455. In that case, thousands of consumers in Ontario purchased a particular car called a Firenza on the basis that General Motors had warranted that it was tough, durable and reliable. It was none of those things, and a representative action was brought seeking damages for breach of warranty and misrepresentation. It's right to say that to some extent the case has been overtaken by the later Supreme Court of Canada case my learned friends rely on, Western Canadian Shopping Centres against Dutton. It's been overtaken in the sense that in Nakin, the Supreme Court of Canada thought it should await legislation before embarking on a class action of that sort. In Dutton, it was said that that was unnecessary and it could make what it could of the existing rules. But the particular feature for present purposes about Nakin, which is illuminating, is that the representative claimant sought a uniform award of damages of $1,000 for each class member, even though their individual circumstances would have varied as dramatically as the circumstances in the present case. Writing for the court, Mr. Justice SC posed the question at electronic page 468, whether by standardizing or placing a limit on individual damages at $1,000 and limiting the class to owners who'd relied on particular advertisements, the action could proceed as a representative claim. He held not, and one reason, which we see at 469, is the variation, the wide variety of individual circumstances of class members. And my lord, that is another indication of the inappropriateness of an artificial limitation in this context. Just before we leave Nakin, it's noteworthy that at page 470, another concern of the Supreme Court of Canada was the res judicata concern I mentioned a moment ago, namely that those with greater claims might find themselves unable to pursue them because the representative had curtailed the claim or capped the claim at $1,000. Then, my lord, finally, in what is, I believe, the most recent judgment in this country dealing with a representative claim for damages, Mr. Justice Stuart Smith, as he then was, had to consider in a case called Jalla and Royal Dutch Shell, which is at page 3081 of the authorities, whether what he described as the expedient of represented claimants abandoning their individual claims for damages with the direct purpose of making the claim appear more closely aligned to the present case meant that they could pursue it as a representative claim. And he held that it couldn't be pursued. I'll just give you the paragraph numbers. 17 is where he described it as an expedient, 29, 70, and 75. And the point he essentially makes at paragraph 75 is even though they had disavowed their individual claims for damages for strategic reasons, the legal nature of their claim remained the same. It was a claim by individuals affected by an alleged tortious act. And so that artificial expedient, different to the one in our case, but comparable, didn't allow the representative action rule to be used. And my lord, we submit that a combination of the consistent interpretation of our representative action rule and the unsoundness of the disavowal of personal circumstances in order to artificially come within it is not acceptable or appropriate. My Lord, our next point is this, and I've trailed this already. We say the representative action which the Court of Appeal has allowed to proceed in our case is in effect an opt-out class action, which we say should not be developed by the courts, but left to Parliament. And I've shown you a moment ago, and we respectfully remind you of it, the observation of Sir Andrew Morritt in Emerald Supplies at paragraph 37, we say is in point, rather than stretching a rule which was never intended for this purpose, this should be left to Parliament. And my Lord, the link between the last topic I was addressing, the legitimacy of a uniform per capita lowest common denominator approach to damages, and the need for legislation rather than judicial creativity, is in our submission plain. The representative claimant seeks an award of damages in his own words, on an aggregate basis, without any individual assessment. We submit that such an award is inconsistent with the compensatory principle in English law, which requires an individual's entitlement to damages to be assessed by reference to their personal circumstances. And that abrogating that rule, the compensatory principle, in order to facilitate a class action may be permissible to the legislature. It is not, we submit, permissible to the judiciary. And we point to section 47C2 of the Competition Act 1998, which was centre stage in the Merrick's case before this court, where which provides in terms for an aggregate award of damages without individual assessment of the damages recoverable by members of the class. And in Merrick's, both the majority and minority judgments remarked on the radical modification of the compensation principle which this statutory intervention involved. That was the language of Lord Briggs at paragraphs 58 and 76. And in my Lord Sales and Lord Legate's judgment at paragraphs 93, 102 and 120, it was described as a major innovative feature which abrogated the compensatory principle. And my Lord, I'm indebted again to Professor Mulheron in her latest article on this case at supplemental documents, pages 771 to 774, for her discussion of the difficulties that the court faces in making an aggregate award of damages without statutory authority. We say the court should be particularly cautious about judicial development of collective redress procedures for two reasons. One is because this is an area of legislative choice. And secondly, because it's one in which both the EU and domestic legislatures have been and are actively considering the appropriate way forward. And I wanted to just give you two citations from authority which we say support the need for caution. The first is in Nicklinson, the decision about assisted suicide at electronic page 2491 at 2627. Lord Newberger at paragraph 116 of Nicklinson drew attention to the fact that this case, the one before him, was, and this is his language, a case where the legislature is and has been actively considering the issue. And we submit that applies squarely here. We also rely on the words of the Advocate General in Schrems and Facebook Ireland, which we quote in our case, which appear at electronic page 3295. The Advocate General gave three reasons why it was inappropriate to develop a collective redress procedure for consumers, as he put it, at the stroke of a pen. One is that it would be stretching the rule deployed. The second was that it was an issue in need of legislation, and his third was that it had been and was the matter of deliberation and discussion at a legislative level which was ongoing. And my lord, all of those points apply in the present case. I'll take the legislative developments fairly shortly, if I may, because there's no dispute between the parties as to what has been going on, only as to what significance the court should attach to those developments. But we point broadly to two periods of legislative choice. The first is in the period 2008 to 2015. Well, this is our case at paragraph 83. I've got to go quite quickly, but the details are all set out. The first period of legislative choice arose following the recommendation of the Civil Justice Council in 2008 that there should be introduced by legislation a new generic statutory collective procedure which would allow class actions to be brought on an opt-out basis. The government in 2009 rejected that recommendation of the Civil Justice Council and instead decided that it was appropriate to proceed sector by sector because the policy considerations varied from one sector to another. Since that time, Parliament considered but didn't ultimately enact a bill allowing such a class action procedure in the financial services sector, but that fell away before the forthcoming general election, but did then enact in the competition law sector the provisions which were considered in Merrick's, which allow an opt-out class action for competition law claims. And we make the simple but obvious point that in relation to those competition law class actions, there are detailed rules and safeguards relating, for example, to the award of damages on an aggregate basis, the funding of the claim, and many other matters on which there are policy considerations which bear. I'm sorry, I see my Lord Sales has his hand.
Yeah, it occurred to me that in many ways, you can say that the points that you raised in relation to ground one replay in relation to ground two at this stage, because there is no judicial principle as to how you divide up an aggregate set of damages. What you get under the statutory regime are quite detailed rules which introduce by statute principles that will apply, which wouldn't be applied by a court other than for applying the statute.
My Lord, I entirely adopt that. They do replay. I recycle essentially the same concerns. One particularly striking point from Google's perspective is the suggestion that a mathematically calculated figure of billions of pounds will be taken from them, and then if enough people come forward to exhaust it, there'll be nothing to give back. But if there's a surplus, their property will be handed over cypre. And that's a remarkable suggestion without statutory underpinning. But it is nevertheless the proposed basis for the class action in this case. My Lord, the second period of legislative activity that we say is important is in 2016 to 21. And it's important because it's right in this field. It's in the field of data protection. There has been legislative action, but it has deliberately stopped short of opt-out collective procedure for compensation. So Parliament, the legislature, both in Europe and domestically, has actively considered the desirability of this innovation and stopped short. And we set out at paragraphs 88 to 89 of our printed case the relevant provisions of the GDPR and the DPA 2018. The way the GDPR Article 80 works is that certain collective procedures are permitted by not-for-profit bodies of very specific characteristics with the mandate of data subjects. And that includes claims for compensation which are with mandate, in other words, opt-in. But Article 80, subarticle 2, although it allows certain rights to be exercised by such not-for-profit bodies without the data subject's mandate, excludes the right to claim compensation. And that is expressly excluded in the wording of the GDPR. Now, just quickly take you back to that. It's at page 822, first of all. At 822, we have recital 142 to the GDPR, which sketches out the types of collective proceeding which may be brought with the mandate of data subjects and independently of a data subject's mandate. But the last sentence is particularly important. It says that body, organisation or association may not be allowed to claim compensation on a data subject's behalf independently of the data subject's mandate. And that is then reflected in Article 80 at page 827, where if you contrast the rights of data subjects which can be exercised with their mandate under Article 80, subarticle 1, we see it extends to the right to compensation referred to in Article 82 below. But the collective proceedings which may be brought independently of a data subject's mandate under Article 80, subarticle 2, do not include the right to compensation. And my lord, we know, and we've set this out in our case, that the travaux préparatoire to the GDPR explained that this was a deliberate choice because of concerns about US-style class actions in the data protection field. And the language used in the travaux préparatoires is that the aim was to avoid the development of a commercial claims culture in the field of data protection. Well, the relevant documents are at pages 3819 and 3822. So much for the European stage. On the domestic stage, the Data Protection Act 2018 reflects a yet more complex and nuanced set of legislative choices than were made in Europe, because the DPA 2018 acknowledged the possibility that Parliament might choose to introduce forms of collective procedure in the data protection field on an opt-out basis after a consultation exercise had been carried out. And the current position is that the consultation exercise was carried out, and the government's recommendation, its response to the consultation exercise, was that it was not appropriate to introduce an opt-out collective procedure for the recovery of compensation in the data protection field. True it is, as my learned friends point out, that the government response refers to the existence of this case and the possible procedural basis for collective redress it might provide. But we submit it's wholly impossible to read the materials we've collected and digested in our printed case without concluding that this is an area of or for legislative choice, and that both the EU and our Parliament have considered whether to introduce collective opt-out proceedings for compensation in the field of data protection, but have held back from doing so. And then this surely is the clincher. They've held back from doing so even where the claimant is a not-for-profit body. Whereas in our case, we have litigation driven by a litigation funder who is going to take the first and a very substantial share of the pot. If the legislature thinks it's inappropriate on policy grounds to allow such an action brought by a not-for-profit body, the conclusion of the policy considerations where it is driven by hedge funds is plain. And we submit that those considerations make it inappropriate for judicial development to stretch the old rule for representative actions and deliver fully formed into English law a collective opt-out procedure for compensation in data protection. Lord, I have about a quarter of an hour left. I have two more points to deal with. The first is identifiability. Factually, the point I'm sure you do all understand, but you need to understand on this part of the case, is that as soon as an internet user visited a website which formed part of Google's double-click advertising network, the relevant double-click advertising cookie was set on their browser. That happened both before the start of the relevant period and afterwards. And the significance of that is that as at the start of the relevant period, there was already a proportion of iPhone users who had the relevant cookie set, not because of any breach of statutory duty on the part of Google, but because they had visited a website within that network. Those class members or members of the universe of iPhone users were described in argument before the judge as already hads, because they already had the cookie on the first day of the relevant period. There is another subset of iPhone users who were described in argument as the never hads, because it was common ground that just as there were a proportion of those who had the cookie at the start of the relevant period, there were also a proportion who never got the cookie, even by the end of the relevant period. And as the judge says, there was some debate as to the precise figures, but on either side's case, the proportions were substantial. I think the lowest proportion of already hads that the claimant posited was 5%. The proportion of never hads varied, but was significantly greater. And the judge, and he had a lot of evidence on this difficult and technical matter, the judge accepted my submission that it was an essential requirement of a representative action that the represented claimants must be identifiable in practice. And I based that on Emerald Supplies, not just in theory, but in practice. And he concluded on the basis of the evidence that it was not possible to identify and exclude either the already hads or the never hads. And if that's right, it led the judge to a concern we say was an entirely appropriate concern, that if there was no viable method of identifying and excluding individuals who were unaffected, there was an obvious risk that persons would come forward to claim their share of the pot when they hadn't been affected by the conduct complained of. And that would risk abuse. It would also risk persons taking advantage honestly but mistakenly of this huge pot of damages waiting to be dipped into. And the judge found at 96 that, contrary to the submissions made on behalf of Mr. Lloyd, it wasn't enough that the class boundary was theoretically or conceptually clear. He held it had to be clear, it had to be both conceptually sound and workable. And he assessed the arguments put forward on behalf of Mr. Lloyd about the way in which information might come forward in the future, and that might allow, as he put it, most, if not all, individuals to be identified. He said that was a Micawberite response, echoing an approach taken in Emerald. And essentially his conclusion, which he set out at the end of paragraph 94, was Google contends it's not possible to identify and exclude unaffected users. That submission appears to me to be supported by the evidence, and I accept it. My Lord, there are two findings involved in the judge's ruling on this point. One is a question of legal approach. Must it be both conceptually sound and practical and workable, the class, or need it only be formally or theoretically sound? And the second is an evaluative finding of fact based on the evidence that it wasn't possible to identify and exclude unaffected members. The Court of Appeal overturned both the legal approach and the evaluative finding of fact at paragraph 80. They reject the judge's legal conclusion that the class definition had to be both conceptually sound and workable, and dismissed as merely practical factors that didn't affect the formal ability to identify the class, the concerns raised by the judge. Perhaps equally significantly, and without expressly acknowledging that this was what they were doing, the Court of Appeal overturned the judge's evaluative finding of fact without referring to any evidence or facing up to the fact that that was what they were doing. Instead, holding that every affected person will in theory know whether they satisfy the conditions, and that data in Google's position would enable people to be identified. As to the first, my lord, it's wholly unrealistic that someone who had an iPhone both before and during the relevant period could know whether they had had the cookie set before the relevant period started or at some point during it. As to the second, it's not only McCorberite to say that evidence might be available from Google to identify individuals. It was flatly contrary to the evidence that was before the judge about the records which were available, which was to the effect that Google's records couldn't say whether a particular cookie was set on a first or third party basis. Our submission is a short one. The Court of Appeal's rejection of the judge's legal requirement that the class has to be both conceptually sound and workable was wrong, and the Court of Appeal's overturning of the judge's evaluative finding of fact was unjustified and impermissible. Well, there's only one case which touches even tangentially on this, but I'll just bring it to your attention, which is Mr. Justice Stuart Smith again in Jalla, page 3801, sorry. And Mr. Justice Stuart Smith, paragraph 68 of Jalla, metaphorically scratched his head about the difference in outcome between Emerald Supplies and our case in the Court of Appeal, pointing out that if, yes, I think I've given the page number, I hope 3801, but that may be the beginning of the case. But I'll tell you the point anyway, I'm not going to take time finding a page now. The difficulty Mr. Justice Stuart Smith identified, and we submit rightly so, is that if self-certification is enough, then why was the class in Emerald Supplies not satisfactory? Because people there could have self-certified that they didn't pass on the loss and did pass on the overcharge and did suffer loss. And he asks the question rhetorically, why, if the Court of Appeal are right in our case, was Emerald Supplies decided in the way it was? I'm told in Jalla, the electronic page is 3107. I'm sorry if my galloping through these led me to give you a wrong page reference. I think it must have been 3108, but in any event, I've given you the right page number now. My Lord, that leaves me in the closing minutes of argument, issue 3, the Court of Appeal overturning the judge's discretion. And my Lord, this is a serious and important point, even though I shall of necessity take it shortly. The judge held at paragraph 104 that regardless of his rulings on issue 1 and issue 2, he would have exercised his discretion against allowing this case to go forward as a representative action. It's common ground he had such a discretion, And it's trite law that the Court of Appeal can only overturn the exercise of such a discretion by a first instance judge on limited grounds. I needn't trouble any of this court with authority for that proposition. The Court of Appeal overturned the judge's discretionary decision on the narrow basis that the judge took into consideration two irrelevant considerations. Paragraph 83 of the Court of Appeal judgment identifies 5 considerations which Mr. Lloyd urged were irrelevant before the Court of Appeal. They are, I'm sorry, it's paragraph 83 which sets out the 5. At 84, the Chancellor accepts that the first 3 were matters it was permissible for the judge to take into account, but says the same cannot be said of the latter 2. Well, I'm sorry, I'm on page 230. And I've just had my 5-minute warning. Page 230, paragraph 83 lists the 5 factors relied on. Only 2 of those were upheld by the Court of Appeal. Paragraph 84 identifies the 2, and looking back at 83, we see those were the inability to identify the members of the class and that the members of the class had not authorised the claim. We submit that the Court of Appeal was wrong to say either of these was irrelevant. Taking the first matter, the inability to identify members of the class, what the judge had in fact said at paragraph 105 on page 264 was that he was taking into account the difficulties of ascertaining whether any given individual actually falls within the affected class. Slightly different. It's an evidential point. We say, for the reasons I've already given, that the Court of Appeal was wrong to overturn the judge's legal approach and evaluative factual finding in relation to identifiability. But even on the Court of Appeal's assessment at paragraph 80, the Chancellor acknowledged that there were practical factors which went to the difficulty of ascertaining whether any given individual is within the class. He didn't think that meant that you couldn't establish the formal validity of the class, but he didn't doubt the existence of those practical factors. The short point I want to emphasise is that for the purposes of exercising his discretion, the judge was surely entitled to take into account those practical factors. He was on a different point now from the formal validity of the class. He was looking at the appropriateness of allowing this representative action to proceed. And those practical factors which gave rise to the risk of abuse, which he identified, in my submission are plainly relevant. It's beyond argument that they are appropriate matters for the judge to attach significance to and to weigh, and weighing was for him. And Lord, can I just give you one reference before I go on to the second factor? We compare on this point the CAT rules considered in merits, Rule 79(2)E, page electronic 1432. That requires attention at the certification stage of a class action and competition law field to the factor of whether, in respect of any person, that person is or is not a member of the class. So that's under the statutory scheme in competition law, expressly said to be a relevant consideration, yet our Court of Appeal has said it's an irrelevant one. My Lord Sells?
Yes, I did wonder on that whether you might, in fact, link it to the definition of the overriding objective, because the abuse point and the mistake point seem to me to be points going to the policing of who gets the money at the end of the day. And one might say that where you're dealing with those sorts of factors, you're effectively dealing with a disproportionate cost to work out who is entitled to any particular item of money, which would be a factor, you might say, brought into account simply under the overriding objective, where you look to resolve claims at proportionate cost and so on.
Well, I'm grateful for that. We do pray in aid in our case the overriding objective, and we submit that all of his factors were comfortably within the overriding objective. My Lord, in my last minute, may I just deal with the second factor? The second factor said by the Court of Appeal to be irrelevant was that the members of the class hadn't authorised the claim, and the Chancellor says it's clearly established at the end of paragraph 84 that members of the represented class don't have to authorise the claim. My Lord, the judge was well aware of that. He said so in terms of paragraph 100 of the judgment. But, and this is the simple point on the second irrelevant consideration, just because the fact that members of the class hadn't authorised the claim wasn't a bar to a representative action can't mean it wasn't a relevant consideration for the judge to take into account. In truth, my lords and my lady, neither of the matters seized on by the Court of Appeal was an irrelevant consideration, and the Court of Appeal were impermissibly substituting their view for the judge's view of the appropriateness of this action proceeding as a representative claim. My lord, it's just 3:15. Unless I can help further, I've used my time.
Thank you very much, Mr. White. I think we can turn then to Mr. Tomlinson.
Lord, I'm grateful. I may have disappeared a few moments ago. I had some technical difficulties at this end, but I could hear Mr. White, so I didn't interrupt. I don't know whether I did disappear, but if I did, I was still online. My Lord, my lady, this appeal raises fundamental points about the representative action procedure and the law relating to damages in data protection cases in the context of enabling the court to provide access to justice in cases where large numbers of individuals have small claims for breaches of data protection law. The Court of Appeal held that the rules in relation to both were sufficiently adaptable to enable such claims to be brought. That is, as I'll go on to develop later on, consistent with the approach to the representative action rule that's been taken in the highest courts in Australia, Canada and New Zealand. In those jurisdictions, as Mr. White has mentioned in passing, the courts decided that they couldn't wait for legislation to lay down the rules for such procedures, but it was necessary for them to act. This is the province of the courts, where the courts have competence and expertise to make provision as to the rules which govern access to justice and collective redress. Google, on a number of occasions, commended the conventional approach of the judge. But what the Court of Appeal did in this case was provided a coherent and rational solution to that fundamental access to justice problem. Mr. White quoted Lord Justice Mummery's point about in Emerald Supplies, the claimants being engaged in a bold attempt at keeping a procedural novelty alive. It's a bit difficult to see how a procedure which goes back to at least the 17th century as a procedural novelty. But we would characterize this as an innovative attempt to use a well-established procedure to provide access to justice in circumstances where otherwise it will not be available. Otherwise it is not available. And the court will appreciate that we do this in two stages. We seek to analyse one way of dealing with data protection damages, where data subjects can recover for non-trivial infringements of their rights recover damages without individualised proof of distress or material damage. And secondly, by an approach to CPR 19.6, which we say is consistent with its origin, purpose, and also its plain words. The rule, put very shortly, permits damages claims if they don't require individualised assessment. And we say that the way this claim is formulated, individualised assessment is not necessary. These points are of very great practical significance, as the court would appreciate. The court will have seen from various interveners supporting the appeal in this case that in substance they accept that there are large-scale breaches of data protection rules and that claims in practice can't be brought against those data controllers because the mechanism, if this mechanism doesn't work, there is no mechanism for doing so under English legal procedure. We have as we say in our case, we have the extraordinary situation where there's no doubt whatever that the claimant, Mr. Richard Lloyd, can bring a claim against a standalone claim against Google for breaches of his data protection rights in this case. The viability of such a claim was established in Vidal Hall. He could put together a group of individuals and apply for a group litigation order, and no proper objection could be made to that. But it's obvious that neither of those claims are viable. My Lord Sales and Leggett quoted in Merrick's the words of Judge Richard Posner, where he said the realistic alternative to a class action is not 17 million individual suits, but 0 individual suits, as only a lunatic or fanatic sues for $30. That's at 1317. In this case, Google says, well, let's have 0 suits. Let's have no claims at all against us, whatever the breach is, because in practice, nobody is going to bring an individual claim or a group litigation claim against us. And the practicality is that if the mechanism approved by the Court of Appeal isn't available, these claimants and millions in similar situations simply have no remedy. The position is, they say, well, of course, if there's legislation, that will be very different and the legislature can act. But the practicality is that there's no immediate indication the legislature will act, and unless and until it does, these breaches of data protection rights will go unremedied. Google says, well, that this can be left to the regulator to deal with. That's at paragraph 43 of its case. But the court will have noted that the regulator herself submits that the decision of the Court of Appeal in this case complements her regulatory role. That's at paragraph 37 of the submissions of the ICO. That's at 126 to 127 of the supplemental bundle. Obviously, and a number of members of the court have pointed this out already, the two issues really hang very closely together. If the case for a uniform award of damages under issue 1 doesn't work, then the representative action procedure doesn't work either. The one needs the other. We accept, as I think everybody accepts, that the procedure for representative actions doesn't permit individualised damages claims. We're claiming an aggregate award, as Mr. White has said, and I think he accepts that damages claims can be brought under the representative action procedure against an aggregate fund which is constituted, in Professor Mulleran's words, top down, we suggest that the top-down approach would involve aggregate damages for the whole class, and that indeed is permitted, as the court knows, under Section 47C of the Competition Act 1998. That indeed is an innovation, and it's an innovation which we accept is not would be a radical departure from the position under the common law. Although there's no authority on the point, it's there's a departure so radical that it's not one that we're urging this court to take. What we're saying to this court is that the bottom-up approach to aggregation of damages is one which is viable. We put the case, and I don't think it's necessary to go to it. It's at 282 in the particulars of claim, paragraphs 41 and 42. We put the uniform damages award, the bottom-up damages claim, on two alternative bases: on loss of control damages on a uniform per capita basis, or secondly, in the alternative, damages on a hypothetical release basis. In other words, a claim for, it's a nice question whether you call them user or negotiating damages in this context, but it doesn't really matter, a sum by way of a notional fee across the whole class. Make that clear now. Obviously, I'll return to that. The use of the personal data. If we're right, we say that there's a cross-class damages claim which doesn't require the consideration of the individual circumstances of any member of the class, and therefore fits the criteria for representative actions as set out in 19.6 and deriving from its history in the Court of Chancery. So, my lords, my lady, with those introductory words, I turn immediately to the first issue.
Can I just ask Mr. Thomason to clarify for me? On your approach, does payment of the aggregate amount operate to discharge Google of all liability to the class?
It does. And I'm sorry, my lord.
So presumably the procedure in representative action brings about an estoppel by way of res judicata, or I don't know how you put it, but some sort of estoppel that would prevent members of the class from claiming anything above the lowest common denominator award.
Yes. But of course, there's the members of the class can apply under 19.6 effectively to be removed from the class. Under the old procedure, it was common for individuals to be joined as defendants who are members of the class, but for whatever reason disagreed with the representative and the way the case was being put. On the facts of this case, as Mr. White accepted, the position doesn't arise because the limitation period has expired. But of course, I accept that if this procedure works in the way that we put it forward, that issue will arise in the future. But the position, there are two points really to make in response. The first is the procedural point that a member of the class can apply effectively to opt out. The second is what we're dealing with here are mass consumer claims for very small amounts of money, and the practical likelihood of someone wanting $35 rather than $30 and therefore seeking to opt out of the class. There may be fanatics and lunatics who would want to do that, but it's likely to be a very rare case in practice.
And will you at some point explain to us what the legal basis is for a person being stopped without their knowledge or consent?
Well, my lord, I will. It's dealt with. It's dealt with. I'll take your lordship and ladyship in due course to the authorities. But put shortly, a member of the class is a party to the proceedings, unless the effect of the representative action procedure is that they're a party to the proceedings. They take the benefit of the proceedings, and the classic, the classic use of this procedure in the Court of Chancery was to determine collective rights, particularly to do with land and other matters. And obviously, once those rights had been determined, they were binding on everybody who'd been represented. And that's a procedure which was, from what one can gather, very well used, certainly from the 17th century onwards.
Yes, but we saw this morning that Lord Justice Fletcher Moulton, I think it's at 894, explains that the reason why that couldn't apply to damages claims where people had individual rights of action was because that would be because in the absence of a common interest, to create an estoppel in that way would be wrong. But I suppose you'll be taking us back to the marked case at some point.
My lord, I will. So, my lord, my lady, in relation to the common issue, the first issue, as I've said, what the representative claimant seeks to do in this case is to create an aggregate fund based on a uniform per capita sum in one of two ways. And the Court of Appeal held that, in principle, they could do that under Section 13 without proving pecuniary loss or distress on an individualised basis. That's paragraph 226. I'm so sorry, my lord, Lord Sales.
Yes, I'm sorry to interrupt you, Mr. Tomlinson, but I just wanted to pursue the point that my Lord Reid was raising before we lose it completely. I suppose you could say that in the cases where there is a common determination of some property right, for example, as we saw in the Duke of Bedfordshire case, that you could have members of the class who will be bound by the results in the case, even though they weren't active members of the class. So they didn't have the opportunity, if you like, to present their own argument as to why that right did or didn't exist. But it might be said that in relation to that sort of situation, they will at least have had the benefit of people who were strenuously arguing and presenting the arguments to the court, which covered their case, and one could have confidence that they were going to present the argument in their favour. So I can see that you can say that to a limited degree, in that sort of situation, someone is going to be stopped even if they didn't participate in the proceedings. But as I say, that's in circumstances where one can have confidence that the arguments essentially were all being presented, albeit by others. Isn't there a very significant difference when one moves on to a claim for damages, where if you extend the estoppel, which would apply in the first category of case to that, people are going to be bound by the result in the action, even though no one has been arguing on their behalf in relation to matters which affect them and their rights.
Well, my lord, that's right. But our response is this: that you have many hundreds of thousands or millions of consumers who have very small damages claims. So those are damages claims which, in practice, nobody can pursue or argue individually because they're too small. If there are outlier cases where someone says, because of the Safari workaround, this and this happened to me, and I lost my job, and I've suffered damages of tens or hundreds of thousands of pounds, then they can apply to opt out. They can apply to become defendants, or they're not bound by the decision that's been taken in relation to the class. It's possible, of course, yes, that there are individuals who've suffered large losses who don't bring cases, who know nothing about the litigation but don't themselves want to bring a case, and yes, those would be bound. But my lord, the practicality of that is in terms of the adversely affected individuals is outweighed, we say, by the practical utility of creating a mechanism for access to justice which benefits hundreds of thousands or millions of people.
But I mean, to what extent is it right for a court to weigh practical advantages against what might be said to be fundamental principle in terms of people having their rights determined without any opportunity on a critical point of presenting argument to the court in support of their rights?
Well, they can apply under CPR 19.64 to
0.6, do you mean?
but not, give me a moment and I'll call it up. 19.64. It's 19.6, but it's sub rule 4, my lord.
Yeah.
If your lordship just gives me a moment, I'll.
Well, while you're looking it up, I think I know the point you're going to make, that they can protect themselves by seeking to have themselves removed from the class. But I wanted to ask you about that. I mean, why should their ordinary rights be burdened in that way? So that if they want to protect their right, A, they have to know about the claim and how it affects them at the time when the claim is going on, even though the penny may only drop for them later on that actually they have a big claim. And B, in any case, why would it be right to burden their ordinary rights with some sort of onus on them to take themselves out of an action which they want no part of?
Well, my lord, it's at 812 of the electronic bundle, the 19.64, unless the court otherwise directs any judgment order given in a claim which a party is acting as representing this rule is binding on all persons and may only be enforced against a person not a party with permission of the court. Well, your lordship has my answer that we're not here comparing your lordship is postulating a situation where someone doesn't bring or want to bring a claim for a larger sum, so has rights that they don't wish to exercise, and yet they're represented as it were part of those rights by the representative in the representative action, and if they choose to stand by and do nothing, then we would say that and take no steps whatever to enforce their rights, because not only are they're not suing individually, but they're not applying to be discharged from the representative action. Lord, we say that that's a consequence which should follow.
But all right. Just one last question. They may not know they have their rights at the time that the class action is going on. They may be supremely indifferent until much later, when they suddenly realise that they actually might have quite a good claim in their own right.
Well, they could apply after judgment under CPR 19.6. 4, they can apply at any stage. But my lord, yes, I accept, as I must, your lordship's point that in one sense that the potentially greater rights of some class members are burdened, are potentially burdened by the representative order. Although we would say that would apply in almost any representative action, because there may be special considerations relating to property rights that if what's being litigated is some kind of rights against the lord of the manor, it may be that some particular tenant has some for some reason some greater right which is not known about by the class representative. This procedure is a procedure of convenience which was devised by the Court of Chancery precisely to avoid the situation of having numerous litigants, each litigating over their own rights.
Yes, thank you. I'm sorry to have taken you out of your course.
Not at all.
But when we come to Marx, we'll see that that's a case where we had all the different shippers of the different cargoes in the same ship that was lost. And the Court of Appeal said, because they're different contracts, you can't have one shipper purporting to bind the other shippers and bring about an estoppel of claims by those shippers who have their own right of action.
Well, Lord, as your Lordship may appreciate, I would say that Mark was wrongly decided, and that the judgment of Lord Justice Buckley is to be preferred. The only conflict that was anticipated was between the shippers who were shipping contraband and the other shippers, and indeed, I think Lord Justice Vaughan Williams was of the view that the separate contract didn't matter, because it was the contraband issue that caused him the problem, and the writ was in a terrible mess, as one can see from the judgment. So, Lord, I don't see that case as there may be many other barriers to my arguments, but I don't apprehend that Marked is one that need detain the court. But I will return to it.
But as one you'll be asking us to disapprove, to overturn.
Well, certainly to disapprove, yes.
Yeah, I see.
So did my Lord Burrows have a question?
It's actually been taken over by some of the questions of Lord Sales. I think you ought to get on, if you like, at this point.
Thank you. Better start moving more quickly. I've made reference to the way we put our case in the pleading, and I won't in the draft pleading, paragraphs 41 and 42, 292. I won't go back to that. What the Court of Appeal held that each class member had suffered damage within the meaning of Article 23 of the Data Protection Directive in Section 13. Their reasoning is at 210 to 225, and we support that reasoning for the reasons advanced in our case at 150 to 165. We agree with the submission put by the Information Commissioner that the paragraph 26 of her submissions at supplemental 8123, that was supplemental bundle 123, that the Court of Appeal's interpretation acknowledges loss of control as a form of damage, reflecting the importance and intrinsic value of the right to exercise control over personal data, and allowing room for the courts to ensure a judicial remedy is granted in a given case, which is effective and proportionate. In relation to the issues that arise as to whether loss of control can constitute damage for the purposes of the Data Protection Act and the directive, we make essentially 7 points. The first is, and we say that this is of some importance, that the directive is aimed at protecting the fundamental rights and freedoms of natural persons, and particularly their right to privacy in respect of the processing of personal data. The objectives of Article 8 of the European Convention on Human Rights are given effect to in the directive. The Court of Appeal set this out at paragraph 40 at 219, and the right to protection of personal data is itself a fundamental right under the EU Charter. We say that it follows from this that the same principles should apply to compensation under Article 8, under misuse of private information, which is the tort which is constituted by the absorption of Article 8 and Article 10 into domestic law, and the principles that apply to compensation for data protection breaches, they should be consistent. As the Court of Appeal put it in Vidal Hall at 1098, it's irrational to treat EU data protection law as permitting a more restrictive approach to the recovery of damages than is available under Article 8 of the Convention. That's paragraph 77 of the judgment, as I say, 1098. That's my first point. Secondly, under Article 8 and the tort of misuse of private information, damages are recoverable not just for consequential harm, for pecuniary loss and distress, but also for loss of control or loss of autonomy. The leading case is already been referred to, is the decision of Mr. Justice Mann on the Court of Appeal in Gulati and then MGN. And it's important to note that in that case, the issue wasn't, as Mr. White sought to characterize it, as a narrow one. The argument was the issue that Mr. Justice Mann decided and was upheld by the Court of Appeal was whether damages, in the absence of material damage, whether the only damages that could be recovered were damages for distress. One sees that at 1150, that's paragraph 108 of his judgment. And he went on to hold at 1152, paragraph 113, in my view, a regime in which damages are confined to damages distress would render the rights to a degree illusory and would to a degree fail to provide an effective remedy. And he, after considering various domestic and Strasbourg cases, he concludes at paragraph 143, which is electronic bundle 1160, misusing private information without causing upset is still a wrong. I fail to see why it should not of itself attract damages. Otherwise, the right becomes empty, contrary to what the European jurisprudence requires. Upset adds another basis for damages. It does not provide the only basis. As the court's already heard, that decision was upheld by the Court of Appeal. Lady Arden gave the leading judgment, which the rest of the other members of the court agreed. The defendant's submission in that, I'm so sorry, Lord Leggett. So
only if it's convenient. I was waiting, whatever, but since you've stopped now. Your argument seems to proceed, Mr. Tomlinson, on the basis that just because at a very abstract level, both these rights are rooted in privacy, it must follow that damages can be calculated on a similar basis. But I don't see why that must logically or necessarily be so. We were shown a case this morning that indicated that Article 8 breaches might be reason-based or consequence-based, I think was the distinction. And in some cases, you might have to show harmful consequences. And in the realm of data, there's surely a significant difference between personal data in relation to which you have a reasonable expectation of privacy and data in relation to which you do not have a reasonable expectation of privacy. And it'd be perfectly irrational to say that only the former would sound in moral damages, if you like, or be actionable per se, but not the latter.
That was the argument I addressed to the Court of Appeal in Vidal Hall and was rejected, my lord. But the issue about data, and in a sense this is fundamental to this case, it is whereas items of personal data like for example, a piece of personal data which is always disclosed when you log on and the Safari workaround came into operation, where you're resident, it is obviously, in one sense, not private data, and it's quite trivial. On the other hand, that's then used with other data combined with other data as part of Google's overall data marketing operation. It has value to Google, and it's used by Google potentially to direct adverts at you, because it may well be that they know that if you live in a particular area of the country, and these are very narrowly defined, that you're a particular type of consumer. So we although on one level, of course, personal data which isn't private can be quite trivial, we're talking here about an economy which uses that personal data as the foundation of a huge economic apparatus. Lord, we do say that it's important for all of us as individuals, for data subjects, to be sure that data is being processed in accordance with the rules, and it's not being used in ways which are potentially in breach of the rules and potentially detrimental to us. But Lord, I'm so sorry, I didn't answer the beginning of your question. It's my fault. I say very shortly that the fundamental aims of the data protection right and of Article 8 are the same. They're to protect the private rights of individuals. And the approach, as the Court of Appeal said in Vidal Hall, it's irrational to approach damages differently in the two situations.
But the mere, sorry, just one more follow-up. See, Lord Sales is waiting. But the mere fact that Google can make money out of it doesn't prove the point by itself, does it? Because people can make money out of finding out what information is in the telephone directory, and if they can put it all together and analyse it and other publicly available data, they may be able to say it. But that doesn't mean that you have suffered some moral injury because that data has been used, which entitles damages per se, if you've not suffered any actual harm.
Well, you consent. You consent to putting your data in the telephone directory, and if you consent to Google having your data, you can't complain if you consent to them using your data. But if you don't, the mere fact they can make money out of it, of course, isn't the end of the analysis. But if they're making money out of it by breaking the rules, then your right to have your data processed in accordance with the rules has been infringed. Lord,
yes, thank you, Mr. Tomlinson. I mean, it's really, perhaps it's pursuing the same line. You're very keen, if I may say so, to get into Galati and to say that provides the measure of damages when you're dealing with an Article 8K. But in fact, if one looked at the Article 8 cases and the principles there, it seems that certainly ordinarily the Strasbourg Court would not award damages in a case where there wasn't actually material harm. And Mr. White took us to the communication issued by the Strasbourg Court and the leading Strasbourg case. So are you going to help us with that? And going back, if you like, to the root source of the Article 8 position, rather than just fixing on Galati and saying that we have to take it from that?
Well, Galati looked at some of the Strasbourg case law, and the case that's mentioned there and that we mention is a case called Holford in the United Kingdom, which in Holford the compensation was awarded to the Alison Holford in circumstances where the court had found expressly that she hadn't been caused distress or any consequential loss by the interference with her Article 8 rights. I can give you the electronic reference.
If you're going to come to it, let's deal with it when you come to it. I won't take you out of your course. Thank you.
It's not essential that you define the right in terms of Strasbourg case law. I appreciate certain principles of Strasbourg case law are important. The actual property right, or the right, whatever it is, doesn't have to be the same.
Milady, exactly so, and I draw on. Of course, Mr. White emphasised very strongly that we're talking here about a domestic tort of breach of statutory duty, and I'll come on to say something about that in due course. But misuse of private information, Mr. White and I argued about in Vidal Hall as to whether that constituted a tort at all, and the Court of Appeal in that case accepted that it was a tort, and that tort has certain characteristics as to how damages are awarded under it. And one of those characteristics is you get damages potentially for distress. And another characteristic of that tort is that you get damages are available for loss of control of the data, loss of control of the personal information. And we say that the two torts are very closely aligned. Of course, they're not identical, and we deal in our case with various reasons, various points on that, and Mr. White deals with it in some detail. But we say it's, in the words of Lord Dyson and the President in Vidal Hall, it would be irrational to treat the two as different. I was simply going to say, in addition about Gulati, and this is my second point. Still, I was simply going to draw attention to the fact that in Gulati, Lord Panic for MGM submitted that it was wrong in principle to award damages for loss of control. I mean, rather like Mr. White's submission in this case, he said you could only get either nominal damages or exemplary damages if there was no consequential loss, and that argument was expressly rejected by the Court of Appeal. And I'll just give you the reference and won't read the paragraph. It's paragraph 45. The electronic page number is 1205, and this court refused permission to appeal on the grounds it didn't raise an arguable point of law. My third point under this heading concerns the position of young children and others who lack the capacity to feel distress. On Google's analysis, they, in the absence of material damage, they can't recover any damages under the Data Protection Act because the only available damages would be for distress. That is inconsistent, and this was a point relied on in Gulati, as the court may know. That's inconsistent with the position in relation to Article 8 and also misuse of private information. I'll simply give the court the references. There are two cases, one called AAA and Associated Newspapers at 2377, and the other case is called Weller and Associated Newspapers. Unfortunately, the bundle contains the wrong judgment. It contains the Court of Appeal judgment at 2415, but that judgment makes it clear that damages were awarded at first instance to 10-month-old twins who obviously could feel no distress, but it wasn't the subject of an appeal, so there's no discussion of it in the Court of Appeal. But those are two cases in which misuse of private information damages were awarded to children who couldn't feel distress, and we also, the point is developed at greater length in the submissions of the fourth intervener that we adopt. I'm not going to repeat them, but they're at supplemental bundle 169 to 172, where interveners representing, among other things, the interests of children, point out that on Google's interpretation, children would not be entitled to damages under the Data Protection Act. my fourth point, which I'm not going to have time to develop very long, is that Google's construction of Section 13 limits the availability of other remedies under the Data Protection Act, because other remedies which are dealt with in Section 14, and the relevant part of Section 14 for some reason doesn't make it into the main bundle, but is in the supplemental bundle at 230 to 231. That provides for remedies of inter alia rectification, blocking, erasure and destruction. Apart from the case of inaccuracy, those remedies are only available if the data subject has suffered damage in circumstances entitling him to compensation under Section 13. So if Google is right, those remedies are not available to someone who doesn't suffer material damage or distress, however egregious the breaches. Those submissions are also dealt with in the submissions of the fourth intervener at supplemental 166 to 167. And I won't move on to my fifth point, looking at the time. Yes, but would wish it.
Well, thank you very much, Mr. Tomlinson. I think we have enough to think about overnight already. We'll adjourn then for the afternoon and sit again at 10:30 tomorrow morning.
Thank you.